Wow, that was pretty horrible stories right there. And if you have more information about Jamie, please let the authorities know. Again, you can go to lawandcrime.com to follow more of the top trending stories of the day. Now, one thing you may have missed yesterday was a case that we were covering. It's called the Rembert case out of Ohio. You might have remembered last week we were saying we were going to cover this one. We were excited for the trial. This was a man who was going to be on trial for the murder of 4 individuals. Specifically, I'm talking about Rena Mae Payne, Kimberly Hall, Jerry Rembert, and Morgan Neitzel. These 4 people, this is spanned from 1997 to 2015. We were going to cover it when Mr. Rembert took a guilty plea and pled guilty to connection with those 4 murders. I want to bring in my very special guest right now to talk more about this, and that, of course, is our Law and Crime trial analyst, Jonna Spilbor. Jonna, it's great to see you, even though you're not in studio.
I know, and I miss being there, but good to see you, too.
Good to see you, too. Now, I know we haven't had a chance to really talk much about this case, but from a general standpoint, and we're not going to reveal the verdict just yet. I'm going to play it in a second. Why would somebody on the eve of this trial take a guilty plea?
There's really one reason and one reason only, and that the alternative, by not taking the guilty plea, could ultimately result in that person doing more time. It's always a tit for tat when you enter into a plea bargain, and I'm going to presume that he's saving himself some serious prison time by taking this plea.
And he probably thought that a jury wouldn't side with him, that the evidence was too strong. Well, let's see what happened, because yesterday was the sentencing hearing. And one of the things that we've seen a lot of times in sentencing hearings is that victims are allowed to provide statements to the court for the judge to consider when the sentence is handed down. So here's a compilation of some victim impact statements that you may have missed in the Robert Rembert case out of Ohio. That is heart-wrenching. You're listening to the family members of the victims speaking out to the judge during that sentencing hearing. Back here with Jonna Spilbor. Jonna, how much does a judge at this point take into consideration those statements, or is it a situation where it's more for the family members of the victims to speak out, it's more cathartic for them, or as perhaps this judge has already made her decision, you know, that she already knows what she's going to sentence him to?
I think most of the time judges know what they're going to do in a particular case. And the victim impact statements, which are pretty much allowed or mandatory, if it, for lack of a better word, in most states, is really for the victims. It's a chance for them to participate. Not all of them are going to be witnesses in a trial, for example. Not all cases result in a trial, but it's their way to tell a judge exactly what's going on in their lives because of this crime. And I think if they're going to change a judge's opinion one way or the other, if there's a chance for a judge to increase a sentence by a little bit or a lot, sometimes these victim impact panel statements will serve that purpose.
Well, that was the prosecution putting forward those victim impact statements. So who did the defense put forward? I'll tell you who they put forward. The defendant himself. He provided a statement to the judge, to the family members, and to that courtroom. Let's see what he had to say. So in other words, that is 30 years to life. He's sentenced to life in prison, 20 years eligible for parole, but no matter what happens then, would still have to serve an additional 10 years. This guy is 48 years old, so the minimum he would be serving is 30 years. You can do the math on that one. Jonna Spilbor, listening to this, so what did you think of that sentence?
Honestly, I think it's a little bit light, and it scares me because if he were to be released on parole in 20 years, and he only has that additional 10 to serve, if something happens, if this defendant is allowed to appeal, and sidebar, typically when you enter into a plea agreement, you do waive your right to appeal, but we don't know that at this juncture. He could actually get out in time to live a good portion of his life. But the one other thing I want to say, Jesse, is this judge keyed in on a word that I really like. She said the healing process, not closure, the healing process can begin. And I love that word because closure is something that happens when you break up with a boyfriend or you suffer a divorce. Somebody dies in your life, you never get closure. These victims will never have closure, but hopefully they can also start to heal.
And that's really the most important thing out of this whole situation. They were maybe able to start the healing process. It's a different chapter for them. And from all of us here at Law and Crime, we do extend our sympathies and best wishes to them. All right, everybody, we're going to take a quick break. When we come back, we're going to talk about the Carl Wimpy Jr. trial. Stay tuned. Okay, maybe this isn't as clear-cut as we thought. I'm back here with Jonna Spilbor. What do you think about the defense's argument that this was a matter of self-defense? Mr. Vasquez was an active participant. And let's not forget that he has a lot of conditions that we got to take into account. He was taking anti-seizure medication. Maybe it's not to say that Mr. Wimpy was the direct cause or the proximate cause of his death.
Right. That'll be interesting. If the defense here can prove that this was a case of self-defense, it takes murder completely off the table, Jesse. But even if they can't, I just looked up the statute in Ohio, and it says that you can be charged with murder, because I was concerned that this case was charged as a murder case from a bar fight. Typically, you don't see that strong of a charge from a bar fight. But in Ohio, if you commit an assault where death is a, quote, distinct possibility, you can be charged with this extraordinary charge. So the defense has a 1-2 punch here. Prove that it was self-defense, this case goes away, or prove that this was not a case where death was a, quote, distinct possibility based on the nature of just your run-of-the-mill bar fight.
One of the things the defense attorney said, is that, or maybe it was the prosecutor, that motive and intent are not elements here. They don't need to prove any of that, and that's huge. Intent, this is not like a premeditated crime.
Exactly. Well, that's why it's not a first-degree murder, and you never have to prove motive in any case, which is something we'll talk about when we're talking about the Moore case. But yeah, so this is a different level of murder, and I think personally, and we'll see how this case plays out, they probably overcharged it, and my guess is when we get to the end of this trial, whenever it is, there'll be other options for the jury to choose from here.
I mean, I always like these cases where you don't know which way it's going to go and how people are split one way or another. This is not so simple, and unfortunately, these kinds of bar fights happen all across the country, and maybe this can set a good example one way or another based upon the law. We'll take a quick break. When we come back, a lot more to discuss. Stay tuned. Okay, so Jonna, I want to talk about this. One of the big discussions is what caused the death of Daniel Vasquez. One of the legal terms that you keep hearing is proximate cause. Can you explain to us what's happening here? Because the defense is saying there's a lot of other factors to consider when we consider what happened to Mr. Vasquez, while the prosecution is saying it's pretty straightforward. Wimpy hit him in the head and he fell and died. So explain to our viewers, what are we talking about when we talk about this causation factor?
Okay, so causation is extremely important when it comes to not only criminal cases, but civil cases as well. And in a nutshell, what it means is the act that someone is being charged with has to have proximately caused it. In other words, there has to be a nexus, is the legal term of art, or a connection between the act and the resulting injury. And if I can give you, let me dummy down an example for you. Let's say I get really mad at you, Jesse, and I shoot you in the kneecaps, which I would never do. And you heal in the hospital, and on your way out of the hospital, you get run over by a bus. You can't charge me with murder because there's no nexus between my shooting you in the kneecaps and you dying. However, if I shoot you in the kneecaps and you end up getting a terrible infection, that kills you. The gunshot wound doesn't, but the resulting infection does. Because I put that in motion, I caused you to be in the hospital. Then you can say my action proximately caused your injury. And it's a subtle difference, but that's where we are with that definition.
And that's that little nuance that becomes huge in this case. I want to play the testimony of Dr. Rembert Forney. Now, this is a toxicologist who's going to describe what drugs or substances were in the victim's system. And we're going to ask, does it matter? Let's see this testimony right now. Okay, Jonna, what is the defense trying to get at here? They were the one who introduced this idea of what was in the defendant's, the victim's system. We're talking about a man who got hit and fell to the ground and died. Does it really matter what was in his body?
So I think what the defense is going for here, Jesse, is twofold. On the one hand, they want to show that he had this cocktail of drugs in his system, perhaps to further the argument that he was an aggressor. In other words, to get to their self-defense defense. That's one route that I think they're taking. Then the second is, are they going to bring an expert testimony down the road to show that there was an intervening cause of the death? In other words, the punch or whatever the blow was that knocked this victim to the ground didn't cause the death, but this pre-existing seizure condition, or perhaps the drugs had something to do with it, where if he weren't on that cocktail of drugs, if he didn't have a seizure condition, he would have survived like anybody else in a typical bar fight would have survived.
Yeah, and the level of intoxication becomes huge here. Was he an aggressor? Was he an active participant? What was his demeanor like? Well, that became a big dispute because there was just a dispute between the sides about what level of intoxication was in the victim, what level of intoxication was the victim had at that point. So let's see a little bit more discussion from from this doctor about what this intoxication was about. Okay, we're trying to analyze the level of intoxication of the victim. Jonna, what did you make of that?
Well, and again, I think the defense is trying to make a good point and is going to be able to make a good point with this was just not, some innocent person who strolled in and got cold cocked, fell to the ground, hit his head and died. This is somebody who may have had a drug addiction, was on a cocktail of drugs perhaps at the time this happened, could have been the aggressor because of that, and could have had some other cause contribute to the death other than a blow by the defense.
But it seems that all he was trying to do was protect his nephew, Arthur Richter, who was in the fight with the defendant, and that it doesn't appear Mr. Vasquez was actively involved in the actual fighting. Maybe he was involved in the altercation of trying to break it up, but if he wasn't the one, any of the aggressors, isn't it dangerous pointing the finger at him and saying it's his fault?
Oh, of course, it's a little bit risky, but you don't have a choice. If you're in this defendant's shoes, you really don't have a choice. He's being charged with murder for, and again, I keep using the phrase like typical bar fight. And I say that because, Jesse, most people who get engaged in a bar fight, there's alcohol involved, obviously. There's some sort of, anger issue going on. Nobody really intends that the other person involved is going to end up dead or that anybody is going to end up dead. So you almost have to go for broke when you're defending a person in this defendant's shoes.
My question to you is, as this case continues, does the defense put on the defendant? Is there any advantage? I mean, if they want to claim that this is self-defense, don't they have to put him on?
For him, he would have to necessarily describe that he was in fear for his safety, for his life, and it may come to pass that he does that. I don't know if perhaps the video is going to, a picture is worth 1,000 words, and maybe that's all the jury's going to need to see in this. But again, this is one of those cases where I don't think the defense is going to decide that, make that issue, turn that into an issue until we get there, till we cross that bridge.
Well, this is an interesting discussion, and we're definitely going to have more of it once we're live in that courtroom. Again, the Carl Wimpy Jr. case is one of the trials we will be live in today, but that's not the only one, because we're also going to be live in the Tammy Moore case out of South Carolina. And when we come back from our break, we're going to talk really about her communications. And I tell you this right now, if you haven't seen or heard about these, stay tuned. It's something to listen to. Okay, we're talking about the first witness of the day in the Tammy Moore case. Back here with Jonna Spilbor, our Law&Crime trial analyst. Yesterday was interesting, Jonna. We saw at the beginning part of the day this whole discussion about an SD card in the Moore's vehicle and trying to track where their movements were. But it was more important because what they were saying in November, remember Heather Elvis disappeared in December. In November, this SD card was taken out. And they're trying to show like the suspicious behavior. In your opinion, do you think a lot of what the prosecution is doing is building their case on suspicious behavior? And is that enough to prosecute?
I think the prosecution's case is going to be built entirely on suspicious behavior, because this is one of those situations where we don't have a lot of solid evidence to connect these dots. In fact, Jesse, this case is going to be largely built on motive, and motive is nothing. Motive is not an element to any crime at all. You don't need it. If you have it, it's like the icing on the cake, but you don't need it. But that's really largely what the prosecution has in this case.
Yeah, it's tough, I know, to prosecute a case, any kind of case, without a body, let alone a kidnapping charge, because that is an entirely different set of circumstances than saying that somebody was killed and disposed of. Here you're saying that she was taken away, and moved against her will. It's a little bit different, a little bit of a different charge. We'll talk more about it right after this break. Stay tuned. Okay, so the feed's breaking up there a little bit. I want to go back to Jonna Spilbor and talk about this witness. Jonna, are you getting the sense that the defense is saying there was not a thorough investigation of this vehicle?
I don't know if I'm getting that sense as much as I'm getting the sense that the defense is trying to show an absence of evidence, perhaps, in connection with this vehicle. Now, you know, the prosecution is trying to connect the vehicle of the defendant with the last place that the victim was seen. And I think where the defense is going is trying to show that maybe there isn't any evidence to connect it to the victim other than its location. But we're going to have to wait and see where he's going with this. He's doing a good cross-examination. I will give him points for that.
So in other words, if there was something to find, they would have found it.
Exactly.
And that's the problem here, right? Isn't it, Jonna? It's not that they're attaching Sydney Moore to the disappearance, because they tried to do that in a prior case. They brought him up on kidnapping charges, and that case ended in a mistrial. They're talking about Tammy. Isn't that a difficulty here? I mean, we're talking about Tammy Moore. So how are they trying to connect her to this? Isn't she a degree separated?
Well, not necessarily, because she's the one with the quote-unquote motive to want this young victim to disappear, right, who's having an affair with her husband. But can we talk for a second about the elephant in the room, Jesse? And the elephant in the room is that this young girl hasn't been seen for 5 years. So let's just presume she's dead.
Right.
But we're not in a murder case here. We're in a kidnapping case. But the victim's not able to say, yeah, this person took me against my will, because she hasn't been seen in 5 years. And that really is an elephant in the room here. Yeah,
because how do you prosecute kidnapping? I mean, maybe they lured her, if you want to believe they had something to do with her disappearance, that they lured her away and then got rid of her. I mean, it probably wouldn't be kidnapping, but we'll talk more about it. So we're going to take a quick break on our end, and when we come back, we'll be live in the Tammy Moore trial. Okay, so Jonna, as we're listening to this, are you a bit baffled as I am that you have this truck that was purchased after Sydney and Heather broke up, and yet it wasn't tested for hair or fibers or DNA, only for blood? That's a bit strange, because this investigator was just assuming that they were in a relationship and she would have been in the car.
Right, yeah. And he's basically, he really didn't search this vehicle with enthusiasm, presuming that he would find hairs, he would find fibers. Which also tells me, though, when he got his marching orders, Jesse, they were probably investigating a murder and not a kidnapping. And what's equally baffling is that where are we going with the orange decorative thing on the outside antenna? That's what I'd like to know.
Well, I guess it's trying to see, well, I think they're actually about to start up again. So let's go back live into the courtroom. Okay, not quite yet. So, Jonna, I guess the real question is it just bad assumptions, bad information that led to this investigation? Because if they're assuming that it was just a missing persons case and not a violent crime, that misunderstanding is what led to this.
I think that's probably where the defense is going, or wants to go with the jury here. Because think about, let's fast forward. All right, he's making points. The defense attorney is making points that obviously there was not a thorough investigation of the defendant's truck or the defendant's husband's truck. Okay. So what?
Right.
Like, in other words, because this is not a murder case, so we really don't care about the blood so much. We're trying to go on, and I guess it would help if there were blood in there, because it would put her in somebody else's truck, the defense truck. But we need to know where this is ultimately going to end up, because as you pointed out, Jesse, the wife is on trial here for kidnapping, right? Not for murder. The husband is not on trial for kidnapping. This is the wife only. So what are we doing? Are we trying to point the finger at the husband as the defense?
Yeah, it's tough. It's tough. Let's go back live and we can listen a little bit more to this investigation. Okay, so let's talk a little bit more with Jonna Spilbor. Jonna, you had mentioned it, and we talked about it earlier, that the kidnapping charge here is really the difficulty, right? So if you're the defense attorney, at the end of the day, aren't you going to say she is presumed innocent? What has the prosecution shown to say that she kidnapped or conspired to kidnap Heather Elvis? And that's the difficulty here, right?
Yeah, and so far we don't have a lot of evidence to support that. I mean, it's almost a really brilliant defense strategy, because there aren't a lot of dots that they can directly connect to this defendant. And you have to, if I'm sitting in the jury box, I'm saying to myself, well, if she's dead, the victim, why aren't we here to try a murder case, which is another thing which may or may not enter into their deliberations. But don't you think that's on the mind of everybody sitting in that jury box?
So what we know is they were initially brought up on murder charges, but they were dropped. From an outsider's perspective, what does that tell you about their case?
The jury's not going to know that. The jury's going to be sitting here, Jesse, wondering, why is this not a murder case? They're not going to have any information to the contrary unless they're doing some homework on their own, which they're prohibited from doing. So I think what you could try to do as a prosecutor is get the jury to connect a dot that you're not able to present evidence in support of. Like, you somehow subtly say, we know that this person's never coming back. We're trying on a kidnapping charge because we can't, or we want to wait to try on a murder charge, or whatever. We're forestalled from charging murder. But get the jury to know that something terrible happened to this young girl.
Interesting. Well, we'll have to see which way it goes. We're going to take a quick break on our end, and when we come back, we'll talk more about Tammy Moore.
They did that, right?
That was a great back and forth there between the attorneys. And back here with Jonna Spilbor, the question of what was in this truck, why wasn't it tested, and what maybe really happened became big issues. What did you think of the back and forth there, Jonna?
Jesse, I'm sitting here wondering a couple of things. Number one, what just happened? And number two, is there some sort of rule in this court that they can't object to ridiculous lines of questioning? First and foremost, the cross-examination by the defense, brilliant. Why? Because you have a state investigator on the stand and who was able to say, yes, 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 yes. So like 50 questions from the defense attorney, not a good look for the prosecution. But then there's more. The prosecution gets up to do its redirect, which was really a cross-examination based on the form of the questions, but I digress, and basically wants the jury to buy the fact that because we did such a crappy investigation, there could have still been evidence that we're not going to be able to show you, but darn it, blood could have been there. What just happened?
Yeah, basically the state said it's possible there was a kidnapping. We just don't have evidence to prove it. We are going to take a quick break. When we come back, as you can imagine, there's a lot to discuss, and we will be live back in that courtroom. All right, we're learning some interesting discussion here. I'm back here with Jonna Spilbor. How important is it for the prosecution to establish that element of control, that Tammy had control over Sydney?
You know, I'm not so sure it's that important. I mean, right now we're listening to Tammy's mother-in-law basically testifying against her, and the prosecution here again isn't scoring a whole lot of points, Jesse, because they're trying to get some information out that's being objected to finally, and the judge is not allowing it in. So it's almost like I have a feeling she's going to be a very short witness here.
Yeah, this is I don't know. It's pretty interesting listening to this relationship and how it went down. Jonna, I'm sorry that we have to sign you off. I know you want to stay and talk more about it, but you'll have you back on to talk more about this case in a little bit.
And I'm going to watch you all day. Thanks for having me as always, Jesse.
Thanks, Jonna. Okay, everybody, we're going to take a quick break. When we come back, we'll be live in that South Carolina courtroom. Stay tuned.